hold a meeting in which they would consider recommending, advising the president whether or not to suspend the judge president.
In the papers, I do not see any reference to the applicant sending a letter of demand to the Judicial Service Commission saying, do not meet or do not make that decision. Is that correct?
It is not in the papers, Justice. However, the extensive representations were made to the Judicial Services Commission as to why it was felt that they were not in a position to advise the president. Certainly, there was no response from the Judicial Services Commission saying that they intended to do otherwise until we received this this affidavit last night.
Yes.
So.
All right. Well, let's move on. So Part A can't be granted. So what's left is your Part B review against the Judicial Service Commission.
My Lord, just in relation to Part A, it is my understanding that there has been an exchange of a draft order between the Judicial Services Commission and the applicant, which draft order is posits that the matter would be removed from the roll in relation to Part A, and it is particularly with the undertaking that's been made in paragraph 22 of the affidavit that was received from the Judicial Services Commission last month.
So what about Part B?
Well, in relation to Part B would therefore then proceed to be heard, and I submit that we would ask your Lordship to assist the parties in putting together a timetable for the filing of papers and hopefully even expedited.
Yes.
For the filing of papers and for the hearing of the matter.
Yes. All right. So where we are now is Part A falls away. I hear you say that there's some discussion about it being removed from the roll. In my view, it seems manifest that the Part A relief should be dismissed. As far as Part B is concerned, indeed, you're perfectly right. You and the representative of the JSC must sit down and work out a decent timetable, something sensible for the exchange of affidavits and heads of argument. Once you've done that, you should email my office and I will fix the earliest convenient date after the heads of argument have been filed in order to hear this. So we'll expedite it on that basis. If you can't reach agreement on the exchange of those documents, you must tell me and I'll unilaterally set a timetable for when this matter will be heard. So then, lastly, what do you say about the costs of Part A that have been incurred up to now? I see the Speaker very generously waives any claim on costs. What about the other parties?
Justice, certainly the Judge President did not asked for costs to start with, really appreciating that the whole motivation of the application is to really have the court ventilate what are serious constitutional issues that are quite novel, and certainly didn't ask for costs, and as I understand, the other parties also have not asked for costs. And it's certainly in the draft affidavit that we've been exchanging with the JSC, the understanding would have been that there would be no costs.
Right. Well, thank you for that. All right. Is there anything else you want to add at this time?
Justice, as in relation to the just on the dismissal of the application, I would submit with respect, Justice, that I think the understanding that the matter would be removed from the roll because of the developments, particularly those of the past hardly even 24 hours. Had that not happened, the matters might continue to have been alive.
Well, there's no point in removing Part A from the roll if it's now, in fact, totally redundant. You must then abandon Part A. I'm not going to leave that on the roll to come back in some dead man walking roll.
Yes, certainly, my lord. However, I would suggest that the dismissal would not be on the basis that there is a failure on the part of the applicant to have made his case, etc. In a case, I'll submit that a case was made out in the sense that there were then responses at the latest possible time.
Well, you're inviting a debate that you might, on reflection, prefer not to engage in.
I'll leave it at that.
At this stage, you have a clear choice. I'm going to dismiss Part A, or you can abandon it.
My lord,
in the future, well, let me go one step back. It seems plain to me on the papers which are presented that there is no case for Part A, even if you thought there was one on the 14th of September when you filed the papers. So therefore, that case must go away. The most generous way to walk away from that is to abandon it. But on these papers, it's demonstrable that the application against the president was premature, and that there's no urgency in the application against the Speaker. And there's no relief sought against the Minister of Justice or the JSC in Part A. So, don't you want to do that?
Certainly, my lord.
Right, okay, so Part A is abandoned, that's done. And then what's left to be done is, as we've discussed, is to get together with the JSC about a timetable. Right, thank you. Thank you. Do any of the representatives of the respondents have anything to say about costs?
DJP for the JSC, we do not take issue around the question of costs relating to Part A proceedings.
Thank you.
DJP, for the president, we also don't seek any costs against the applicant.
Thank you.
Deputy Judge President, as recorded in the Speaker's affidavit, the Speaker submits that no costs order in either direction would be appropriate in respect of her.
Thank you. All right. Mr. Hlope, insofar as you represent the Minister here, is anything you want to add?
No, Justice Sutherland. The only issue, not on costs, but the only issue is that in the light of the exchange between you and Mr. Stagi, whether they should not simply withdraw against the Minister of Justice.
Yes, indeed. Do you want to respond to that suggestion that you should withdraw this application against the Minister, who doesn't appear to have any active role in any controversy here?
My Lord, I've made my views on the issue that it was felt as the Minister of Justice having the responsibility of the administration of justice, particularly in relation to the issues here. That was the basis upon which the minister was cited. To the extent that the court is of the view that it is unnecessary to cite the minister, then we would be open. We would submit that that be done.
Well, it does seem unnecessary to have joined the minister for the purposes of Part A, but it is conceivable that, given the constitutional issues which you raise, it may be appropriate for the minister to have a say on the contentions advanced about the constitutionality of various aspects. So you might reflect on that. Very well. Right, that then is the nature of the order I'm going to make on that score, which then brings us back to the role of freedom under law in this matter. There is no role for them to play in Part A. What do you say about your objection to them in regard to Part B? Is that a position you wish to reflect on?
Certainly, Justice would wish to reflect on that and then communicate our decision.
Very well. So you'd include freedom under law in your discussions about a timetable. And if you decide no longer to object to their presence, then they will fit in with that timetable.
Certainly.
Mr. Du Plessis, are you content with those arrangements?
Certainly, Deputy Judge President. We would invite discussion to ensure that we're included.
Yes. As far as the costs of today is concerned, are you content that that be reserved until such time as there's a formal admission or a debate about it?
Yes, we would. It would seem a bit precipitous for us to be arguing for costs while one foot is still outside the door.
Yes, quite. Right. Is there anything else anybody needs to say?
Not from us.
I've just been sent a message by my junior who says that I should ask whether or not Judge Hlope insists that the matter should be heard by judges from a different division.
Yes, thank you for reminding me of that. Yes, I see that it's said in a letter, although not under affidavit, that there's not a single judge in the Gauteng division fit to hear this matter. Are you persisting in that view?
Justice Sutherland, I may just refer the court to a previous case which has a bearing to this matter. It's cited in the papers, that of Premier Western Cape versus the Judicial Services Commission. Mm-hmm. In that matter, which served before the Western Cape High Court, it was decided that judges from outside the division hear the matter because it concerned the judge president of the division. Mm. And my submission would really to say that there certainly isn't a submission on our part that there isn't a judge in this division that could hear this matter, or that's qualified to hear this matter. However, I would direct this court to this precedent, if you like, that's been set before.
But how can that assist one in these circumstances? But let's go back to your attorney's letter of the 20th of September. I'm quoting: I request that the matter be heard by a judge from a different division, given the implication of Malumbo JP in the review application, and this is the punchline, resulting in the inability of any judges within his division, being impartial enough to hear this matter. That's the ground on which you advanced that request. Is that seriously made? Do you think that all the members of the Gauteng division constitute a swarm of minions who are enthralled to the judge president and who go about sucking up to him on each and everything that he has a whim about?
Justice, I could only say that the content of that letter is unfortunate.
Yes. Yes, well, that's perhaps the only relevant remark to be made about the request. I can put to you now that there seems to be no merit on any grounds for inviting a member of another division to come and hear this matter. It's the responsibility of this division to hear it. I will case manage this matter until the hearing, and a judge of this division will hear the matter. And I hope that will be the last we hear about it. Of course, if you have any reason to seek the recusal of the judge who is assigned to hear the matter, that's a different issue that you'll deal with in due course.
Certainly.
Right. Thank you. Right, enough said about that. If there's nothing else to be said, I'm going to issue an order. Last chance to say something. Right, thank you. Number one, it is noted that the applicant has abandoned the relief set out in Part A of this application. And in the light of the disavowal of seeking a costs order by any of the respondents, all that is necessary is for me to note that the relief in Part A has been abandoned and withdrawn. Two, as regards Part B, the matter will be removed from the roll today for the purposes of, one, the representatives of the applicant and the Judicial Service Commission and of Freedom Under Law to engage with one another to prepare a sensible timetable for the exchange of affidavits and heads of argument. Once agreement has been reached on that timetable, the Office of the Deputy Judge President, Johannesburg, should be emailed with the details, whereupon, number two, I shall fix the earliest convenient date and allocate a judge to hear the matter. These arrangements contemplate that the rules of court as to times and other formalities will be abbreviated in accordance with the agreement of the parties. Main paragraph 3, the application before the court now by the Freedom Under Law to join in the application, now only Part B, self-evidently, will be postponed sine die and will be addressed as and when, at the initiative of Freedom Under Law, it is either re-enrolled or is to be argued at the same time as the main application is to be argued. 4, there will be no costs orders of any kind, and the costs incurred by Freedom Under Law as regards today's proceedings will be reserved for a determination at a later time. That concludes the proceedings, and the court will now.
Thank you, DJP.
Goodbye.
As the court pleases.
As the court pleases, thank you.
Court pleases.